Good morning, everyone. Thank you very much for waking up early. It's not that early, but we still think there's some people that are probably taking a good jog in Miami Beach. But we're glad to be here. The Brazilian panel will be looking at the grand corruption cases that we're having in the country and investigating over the last couple of years. This has proven to be probably one of the largest corruption cases in the world. But we're glad, and during the course of our presentations, we'll be able to show and hope to show to you that the institutions are functioning well. A lot of people were arrested. A lot of recoveries were made for the benefit of the people of Brazil. And I hope to give you a lot of time by the end of the presentation so you can make all the questions I know some of you already have, and we'll be glad to answer. On my left here I have Judge Daniel Carnio Costa. He's a judge on the first Bankruptcy and Reorganization Court of São Paulo. He spoke at OffshoreAlert, I believe, in 2011. To my right here, we have Prosecutor Eronides Santos. Also, I believe the third time at OffshoreAlert. And Dr. Eronides is a prosecutor in bankruptcy, but also responsible for lawsuits related to the loss by victims of the stock market and investments. And in the farther left, we have Judge Marcelo Sacramone, his first time at OffshoreAlert, and he's the judge at the second Bankruptcy and Reorganization Court of São Paulo. All of these gentlemen here deal with many of the commercial issues related to the companies involved in Lava Jato scheme, and we hope to be able to do on this hour and a couple of minutes that we still have, dig as much in as to these details as possible so you can have a better view of this complex issue that we're about to present. Thank you very much for attending, and Judge Daniel will be our first person to present.
Thank you, Henrique. Good morning, everyone. And first of all, I would like to thank you for coming, for being here in this panel. I would like to thank the organizers for inviting me again to come. It's my second time, as Henrique has already said. It's an honor for me being here and have this opportunity to talk to you, especially when it comes to an issue, a so important issue for us, which is the fight against corruption. First, I would like to give you an overview about the fight against corruption in Brazil, where we are, what we are doing, if we are succeeding or not, and I'd like to raise some important issues, then we'll have a good debate afterwards. Brazil, as you may know, is facing now a very serious crisis. Perhaps it is the deepest crisis in its history, the deepest ever. And it is because of the combination of three circumstances. What is the economists used to call a perfect storm. The first circumstance factor is an external factor. We have China's economy is slowing down, and we have the price of the commodities too low. So by itself, it would be enough to cause to the Brazilian economy a huge harm. But in addition to this external factor, we have some domestic circumstances. The first domestic circumstance is economic public policy, a wrong economic public policy. The time has shown that we had, until last year, an economic public policy based on lack of fiscal responsibility. So we spent the money we didn't have, and now we are suffering the consequence of that. To give you an idea, some states in Brazil, like Rio de Janeiro, they don't have money to pay the salary of the public servants. So it's a very serious situation. But there is more. In addition to it, we have a huge corruption scandal. The car wash operation, Operação Lava Jato, has been revealing creeping informations of the relationship between the public sector and the private sector. A huge bribery scandal involving some of the most important companies in Brazil, public companies and private companies. Petrobras, for instance, the main oil company in Brazil, the biggest company in Brazil, it's a public company, is involved in the car wash operation, this bribery scandal. And we have other important companies involved, so OAS, infrastructure company, Odebrecht, Camargo Correia, and other big companies in Brazil, they are all involved in this scandal. And the problem is, when you have Petrobras involved in a scandal like that, Petrobras becomes to have problems. They don't have money. Petrobras doesn't have money to invest in new projects. And Petrobras is delaying due payments because they need to make a verification, a check on the compliance of the contracts. But behind Petrobras, we have many other companies in the oil sector, and those companies rely on Petrobras in terms of performance. If Petrobras has no money to invest in new projects, those companies start to have problems. And the same occurs when it comes to the infrastructure sector. We have OAS. If OAS has problems, the other companies behind OAS will start to have problems too, will suffer the consequences. And now we are starting a new sector in the economy, the telecommunication sector, with Oi. Oi is also suffering a huge crisis, and I already have many companies in this sector fighting for reorganization in Brazil because of this crisis. So, to give you an idea, it happens like a domino effect. It's a domino line. One piece falling after another piece and spreading a huge crisis as we are seeing in Brazil. There is a very interesting phenomenon in Brazil too. These companies involved in this scandal, they are suffering a kind of commercial bullying. The other companies, they don't want to have business with these companies because they are afraid of having some involvement in this scandal. So it makes even worse the situation for these companies. So the economy is shrinking in Brazil. We are living a recession, 2 years now. Brazil has been losing 2,000 jobs per day. We have now in Brazil more than 40 million unemployed people because of this crisis. And this is to say that, as you may see, the fight against corruption is an important component of the Brazilian crisis. We are paying the price for fight corruption. But we are glad to do so. The people understand in Brazil that this is the turning point in our history. We are willing to pay this price, and we are doing so. And I can say we are succeeding in the fight against corruption because of 3 reasons, basically 3 reasons. I'll talk about these reasons in much more on one overview about these reasons, and then Henrique and the other panelists will talk about more specifically about each of these reasons. The first reason why we are succeeding in this fight against corruption is the strength of the institutions. The institutions in Brazil are working properly and independently. The judiciary is doing its work. The federal police is doing a great job. The prosecutors, they are doing a great job too. I'll show you some pictures here to demonstrate the strength of the fight against corruption in Brazil because of the institutions. The former President Lula, I hope you know him, he's facing many charges now, charges of corruption. This is not the carnival. These people are on the street protesting against corruption and calling for the impeachment of the former President Dilma. She was impeached, and she was now facing investigations on criminal matters too. Important politicians, important businessmen are facing charges in Brazil. Some of them are already behind the bars. I'll show you here. The Brazil former House Speaker, Eduardo Cunha, one of the most important politicians in Brazil, he is arrested. Here, Marcelo Debrecht, the owner of Odebrecht Construction Company, one of the most important company in Brazil. He used to be one of the richest men in Brazil. He is behind the bars, and she's facing many charges now. So it shows that the institutions in Brazil are working, are showing the strength of the institutions. And in addition to this, I would say that the second reason for succeeding in this fight against corruption is the jurisprudence of the Supreme Court. In Brazil, the defendant, a criminal defendant, could not be sent to the jail before a final decision. It was not possible. But the problem was our system of appeal is kind of crazy, because you can appeal against a first instance decision to the Court of Appeal. And after that, you can file another appeal to the Superior Court. And after that, you can file another appeal to the Supreme Court. And you have also interlocutory appeals in the middle way. So the path to get the final decision can take a long time, can take forever. So rich people, rich criminals who have money to afford the best lawyers used to use the system of appeals to delay the final decision. And we have the statute of limitations, so this was a strategy to avoid prison. That's why rich people never went to the jail in Brazil. However, 3 years ago, I guess, the Supreme Court has decided that after the Court of Appeal uphold the decision of the first instance, the defendant ought to go to the prison. The defendant has the right to file another appeal to the Superior Court and then to Supreme Court, but the defendant will wait for the final decision behind the bars. So it's not anymore a strategy to delay the prison. And the third reason for the success of our fight against corruption is the collaborations agreement. It's a kind of plea bargain. The defendant has to plead guilt and has to tell the truth and has to present evidences of his participation and about the other participations on the corruption scheme. Present evidences about the participation of other people involved in the scheme. So as you can see, a defendant talking to his lawyer, can we use our system of appeal as a strategy to avoid prison forever? No, it's not possible anymore. It's not on the table anymore. So what can we do to get a better position for me? You have to plead guilt and you have to present evidence of other people who is involved in the case. So let's do it. And in return, the defendant will get a more lenient sentence. So when you put together those factors, you have an efficiency fight against corruption. It's like a formula. Strong and independent institutions, plus the jurisprudence, the new jurisprudence of the Supreme Court, plus the collaboration agreements, equal efficiency on the fight of the corruption in Brazil. This is where we are in Brazil when it comes to fight against corruption. Thank you.
Okay, I'll try to give you with a little bit of details how this investigation car wash started. As Judge Daniel pointed correctly, in the last 3 years we saw a very big change in the country. This decision of the Supreme Court is a key decision that avoids the way criminal defense lawyers used to fight a case. It was, if we look, you can easily find cases in Brazil that are over 20 years old when dealing with white-collar crime. But this investigation didn't start as an investigation against Petrobras or against politicians. Judge Moro, who is a judge in the south part of Brazil, was investigating a money laundering scheme. He had investigated a scheme similar to that in the past, called the Banestado case, which was a case that was verifying illegal transfers of funds out of Brazil, in particular to New York. There was a criminal investigation in New York as well. At that time, in the late 90s, early 2000s, it was identified that over $30 billion were used on that illegal money transfer scheme. Well, Lava Jato started, the car wash actually started an investigation of a small shop, tourist travel agents, because these operations of doleiros, the legal transfers, are usually done by travel agents in Brasilia. And Judge Moro, again, 10 years after investigating this Banestado scheme, was again investigating illegal transfer of funds out of Brazil. So when he did his first investigation on this small shop, he came up with a lot of information related to a specific doleiro. Doleiro is the individual responsible for transferring these assets from one place from Brazil abroad and into Brazil as well, these funds. And this doleiro had bought a Land Rover car for a director of Petrobras, Mr. Paulo Roberto da Costa. So in May of 2014, 3 years ago, Mr. Costa was arrested. And the day he was arrested, they also did a number of search warrants on his offices. He was no longer a director of Petrobras at that stage, but he had been a director of Petrobras for many years. And at that stage, in 2014, we didn't have this new jurisprudence of the Supreme Court. Plea bargains were beginning to be used. It wasn't something big for us yet, like it is in other systems. So this individual was put in jail, and he knew he would stay there for very little. Usually a couple of days or maybe a month, so the police could do all their searches, and then the way our system was at that stage, he would leave jail and he would then wait 20 years for a conviction. So was this new for us, the fact that a big director of a corporation, of a public corporation such as Petrobras was involved in a scheme? It wasn't new. Was it news for us that most of the construction companies in Brazil acted improperly by paying bribes? No, it wasn't new. This is a report from 1993. It's in Portuguese, unfortunately, but if you read it, you will note that most of the construction companies were already accused 25 years ago of the same practice they're being now accused on the Lava Jato scheme. Big difference, at that stage there was no interest of the the system wasn't properly in place to investigate such complex corruption schemes. So that didn't take, we know that a few people, 2 or 3 people were finally convicted on those matters, but not the real players. If you read, Odebrecht is in there, and that's a 1993 report. So going back to the car wash case, that's where, when the police, federal police, went into the shop. So it's a small gas station, a small shop, but they began to get good records for a purpose of their investigations. And then they realized that there were something much bigger going on. The police was very efficient, like Judge Daniel pointed. They, at the same time, did the searches on, that's actually a photo of the elevator of Mr. Costa's office, and that's his family's members living with documents, computers. So at the same day he was in jail, the family was helping him to hide the evidence of crime. So now the family members are being criminally investigated for participating. And that's where really this case, the big change took place. This gentleman now, who was a major director of a company, had made millions of dollars, had his family members now, his children involved in this big scheme, this big criminal investigation. And he started to get worried. But, like I said a little while ago, he was out of jail. By the end of May, they finally got him out of jail. His lawyers were able to get him out of jail. Now we see the international systems, the laws that we always debate and we always hope are in place, act and assist the Brazilian court to combat this corruption scheme. Mr. Da Costa is out of jail, and there's a communication by some countries, including Switzerland, that he had bank accounts. So a month later, when the judge begins to receive information from other countries about offshore companies, and on the Lava Jato scheme, you have probably all the offshore jurisdictions involved, and bank accounts all over the world. So the judge receives that and puts Mr. Costa back in jail. So now he has two criminal investigations going, one against Mr. Costa, and a second one against his family members for assisting him on destroying evidence of the criminal investigations. So Mr. Costa decides to make a plea bargain. He decides to cooperate with the court, with the judiciary. And he points out this huge scheme that no one, not even the judge or the prosecutors involved, were expecting. And the scheme involved people such as other directors of Petrobras, Mr. Barroso, who for now, until a couple of months back, was the leading guy with money, amounts of money that he diverted from the company. Mr. Barroso was arrested, and soon after that, 3 or 4 new directors of Petrobras were arrested, and all of them had figures, incredible figures of funds abroad, in particular Switzerland. This gentleman had over $100 million sitting on bank accounts offshore and abroad. So suddenly the car wash investigation, which was dealing with an investigation on illegal wire transfers out of Brazil, now is in the middle of a huge investigation as to Petrobras. And then came the question, who is paying this? Who are the people paying these bribes? And why are they paying such huge bribes for directors of the company, who's supposed to have systems inside to control, to make sure their contracts are properly done, and there's a compliance, there's the due diligence. And the scheme now reaches the politicians. That's the former chief of the government of Lula, was the leading member of the Labor Party, who was in control of the Brazilian presidency for 13 years. And he was he was already arrested on a scheme prior to that involving paying congressmen for their votes, the Mensalão scheme, how do you say it in English?
Big monthly.
The big monthly scheme, like Judge Daniel translated. But again, he was in the middle of the Petrobras. So he was taken out of government, and soon after that, he became the biggest consultant for anyone that wanted to invest or do business with Petrobras. So Mr. José Dirceu is now behind bars for the second time and will be there for a long time. But the investigation now that it started off as an illegal transfer of funds from a small travel agency in Brasilia, then went on to investigate the largest corporation in Brazil, had 5 of its directors arrested, was now reaching the politicians. So when those directors they were arrested after Mr. Costa, some of them also decided to come out and say, I want to do an agreement. I don't want to be in jail for many years. And why do we think they did that? Because they realized that they wouldn't keep their money, at least most of it, offshore, because the authorities were cooperating with one another. They realized that they would get real jail time. And now, who were they saving? The people they were trying to save and not tell who the real people heading this scheme were, they wouldn't need them ever again in their lives. So now the politicians are in the middle of the investigation. So I treat Lava Jato as a 2 phases. Phase 1, which is this that I described, the directors, the politicians, and now you have phase 2, which has started maybe a month ago. Although Mr. Marcelo Odebrecht is in jail now for over a year and a half, Odebrecht decided to do an agreement with the prosecutors, a plea agreement, and cooperate as well. And it wasn't a surprise to us when the father of Marcelo Odebrecht came out a month ago and said that he has been doing this for 30 years. And not only in Brazil. Those of you who had the chance to read a little bit about what's going on in Lava Jato and the Odebrecht investigations, most of Latin America and Africa and other countries, where they created this system. They had their own bank to do this. They bought a bank on an offshore jurisdiction to pay the bribes. They had a financial, inside their departments, like they have the engineering department, the financial department, the compliance, they had the bribery department. The amount of bribes was so big that they had to create a system, and a complex system. Part of the system is right here on the Miami Ocean, because one of the directors of Petrobras decided to throw his computer here when the investigation was actually gaining speed. So once Odebrecht decided to speak, this goes into a new level as to the politicians. We had maybe 15, 20 politicians investigated at a time, but now it's over 300 politicians. All former candidates or presidents in the last 15 years are being investigated for large figures. Many of them with deposits abroad, offshore jurisdictions. Everybody involved in the campaigns now have decided to cooperate as well. So the marketing company has decided to tell how they got paid, not because they wanted to cooperate, but because authorities were able to identify that offshore companies owned by Odebrecht were paying them. So they had to justify, why are you getting $5 million from an offshore company owned by Odebrecht? And they came up initially with the excuses, very, very poor excuses. And now everybody decided to cooperate. So we don't know what's going to happen in the next couple of months. But what we can we're sure, is that the system is functioning. But Brazil is a large economy. It has large corporations. We were at one stage the 5th largest economy in the world. And when you're investigating such a huge economy, and you have these powerful tools that we described here, it's a long time to do a real cleaning. And what the consequence is, the economy has been down almost 10% in the last 2 years. Unemployment is high, but like Judge Daniel explained, the people are supporting it. The Brazilian people want this to be serve as an example that politicians, if you're going to the public sector, you should be focusing and serve the public. So just to finalize, where are we going? Oh, I forgot. Our probably one of the greatest history. I don't know how much time I have there, Judge.
No, you have time.
I do, okay. So probably one of the greatest history of a politician would have been Mr. Lula da Silva's history. He ran for president 4 times. He didn't have a college degree. He was a member of the unions, and he made it to the presidency. And Brazil, at one stage at least, was doing really well. I don't know if you remember, one of the main magazines had the Christ going up as a rocket.
Times Magazine.
Unfortunately, I was in the United States when I saw the magazine come out, and I was there when the magazine put the Christ going down on a short flight. But Mr. Lula da Silva. Hello. Yes. So this scheme reached him. So he came out of the presidency in 2012, and investigators were focusing on understanding how deep was his involvement. So this is a property in the countryside next to São Paulo, and investigators knew that they checked where the securities for the former president were going, and they realized that at this property they went over 100 times in the year. So they tried to investigate the connection. They took pictures from Google Earth or other systems, and if you note, there's 2 roofs there. One is very red, and the other one's a little bit lighter. That's the new roof. So they noticed by checking the pictures that there was a new construction there. This was very far away from a main city. So the federal police went around the construction shops that sold materials for the construction, and they started to get invoices. And then they checked who were the people responsible for paying those invoices. And it were companies such as OAS and Odebrecht. So the property that the former president uses is under the name of, on the title, under the name of one of his son's partners, received not a lot of money, $300,000 construction, but paid by Odebrecht and OAS. So they went after the furniture, who bought the furniture. So now they have very good evidence that the president received some form of benefit. But they continued the investigations, and they found this apartment on the beach, about an hour away from São Paulo. The building's simple. It's not a huge, it's not a very luxury place. But the last apartment there on the left has 3 floors. Initially had 2, and then below. And Mr. Lula da Silva was caught visiting that apartment a couple of times. He's the former president. If he goes somewhere, there's security, there's some, so it's not that hard to investigate. But when you check the title of the apartment, it's not under his name. It's under the name of OAS. So now he's being criminally prosecuted for both the countryside house and the apartment. And that led to a number of other investigations. All of the gifts he received when he was president, sculptures from all over the world, paintings. When he came out of the presidency, he had to put it somewhere. So they leased a warehouse next to his town, and OAS paid for it. Those things showed a clear connection, that it wasn't just someone making a gift for a president. It was really, whenever needed he had, those construction companies would come up and support his needs. And then they investigated his institute, and most of the presentations he did globally were paid for those construction companies, and much more than Bill Clinton gets paid. So Lula was then a millionaire, supported by the construction companies. So to terminate here, where are we going next? Where is this leading us? Odebrecht is already out there. The list of 300 people is there. But we do have suspicions that there is a lot of investigation still to be done. This is the port of MARRIEL in Cuba, paid by the Brazilian Development Bank, $650 million. Similar to this, there's over $20 billion in projects that the Brazilian Development Bank has financed in countries where Mr. Lula da Silva wanted to have a good political relationship. We don't know if investigations are going to go there, but a lot of the large Brazilian companies that grew extremely in the last 5-10 years were using public money through this development bank. So, in our view, to finalize here, a lot was done. I was surprised when I read the data and to prepare for this conference. Every time we read, we're surprised. I look at the newspaper this morning, another political agreement, 81 people now that politicians had that were not on the Odebrecht list are now brought in. So it is a lot of work. But in the long run, the Brazilian people will be happy about this high price we're paying. Thank you very much.
First of all, I would like to thank you, OffshoreAlert, for the invitation. It was a pleasure to be here. At that point, we heard about corruption cases and huge corruption lawsuits, and it's inevitable to think about, oh, I'm an investor, I have some money, should I put my money in Brazil, or I am in a really great risk? And this really common question is not really easy to answer. Why is that? Because our legislation is not for amateurs. Why is that? We have from 2013 anti-corruption law, and this anti-corruption law establishes that there is strict liability without need to prove any intent of the agent with or if any case or any act against the public, just national or foreign administration. These legal entities will be held liable to act performed in their interest or benefit, both of it. This responsibility or this liability of this company does not exclude the liability of the officers or anyone that was involved in this kind of act. Also, the directors respond or have liabilities by his own fault. And in this particular case, the directors must to be liable, has to be proven that there was intent that the acts were against the public administration. The controlling companies in this act, also the controlling companies, the controlled companies, the affiliated companies, or any kind of related companies with this agent that was act against the public or the foreign administration would be liable as well, but would be liable only for the payment of a fine of the full compensation of the damage caused. The legal entity remains liable in the event of any contractual changes, merger, incorporation, anything, and the successor as well in a merger or in an incorporation will also be liable for any act that was against public or foreign administration. So, as an investor, I would be totally feared. And this fear would be right. But our legislation is not so just anti-corruption, we have liability for other sectors as well, labor sector and consumer sector. A little bit different from here in the US. Labor legislation in Brazil imposes that the company controller will be strict liability, or will have a strict liability for the payment of the workers' obligation, despite of any fact that would involve the company. In consumer code or in our code of consumer protection also imposes the responsibility of the entrepreneur or the farms or the industry for the payment of all debts involving and regard to the consumer as well. So there is a strict liability, independent of any proof of intention or that they don't have assets to pay this consumer or this labor or anything about it. So if you have money to put in Brazil, would you put there? This is our main question, and in this anti-corruption scheme that were presented by Judge Daniel and by Henrique here today, we were really start to think about it. We have to make something so our investor would stay here and would really invest in our development. And as judges, we are in the bankruptcy court. We face it every day with this question that was, we have like huge companies involved in the anti-corruption scheme that were in reorganization. We have OS, we have Chain, we have Camargo Correia. Now we have, these are the three, Alumni, we have Galvão. So the main corruption cases got our main incorporations, and we are facing the question in reorganization, should we clean the company? Should we leave the company and allow the development of the country with this company, or they are in the Lava Jato scheme, they should got in bankruptcy, we should do anything to protect them anymore. This question was answered by our legislation, and our legislation, bankruptcy legislation, said to us, despite of the other legislation, labor legislation, consumer legislation, that this company should be protected. The owner of this company, despite any fact that he got in the anti-corruption scheme, the company has nothing to do with that, and we have to protect this company in these reorganization cases, in bankruptcy cases, so we can develop the country. In this particular scenario, we call that any assets that were purchased by a company in reorganization or in bankruptcy is the less risk that any purchaser could really buy in a lawsuit in Brazil. Actually, this is an intention that the legislation would like to do, is when we have not a huge risk to buy any assets, the buyer would, in an auction, would put a higher price, so the risk should be avoided. So in Brazil, until now at least, in reorganization, in bankruptcy, is the most easier and usually the cheapest way to buy an asset without no risk at all. Actually, the legislation in this point were not so specific with transnational bankruptcy or multinational bankruptcy and reorganization. We don't have in our legislation, in law 11,011, we don't have any kind of clause that establish the procedures when we have a multinational reorganization or bankruptcy. Despite of this fact, the judges in the courts and the jurisprudence in general have changed its position, its previous position, and start in its own decision to recognize the uncitral model of procedure. So we can recognize in jurisprudence, in Brazilian jurisprudence, international affairs. We can establish that reorganization with multi-international corporation can be established in Brazil, and the procedure will be the same. We can cooperate with international judge to find assets. We can cooperate with international judge to establish a common procedure in a reorganization matter. Actually, in this particular case, we have example in Brazil is OGX. OGX is one of the main, or was one of the main Brazilian company. He was owned by Eike Batista, the richest at that moment Brazilian. Eike Batista is in this photo with our former president Dilma Rousseff. When he was at our Bovespa, is our share stock market, when he launched OGX. And in 2017, the beginning of this year, he was arrested in Lava Jato scheme. As you can see in this graphic, this is the reorganizations numbers and rates, and it can shows that when the crisis, the economic and financial crisis was established in Brazil in 2015, the crisis was for reorganization even worse than in 2008 when Brazil got in this international crisis. Here we have more than 10 times more reorganizations and files that we have in 2008. So the crisis is really related, and the organization is really related with our scenario with corruption and things like that, and how can we solve it. In the organization, OAS, for example, we don't have also a deep finance provision in our law as well. And we have difficult at the beginning to accept this deep finance in the second degree, on the second instance in the court in São Paulo. The judicial decision was not provided in time that was expected by the investor and the business. That was, although the first case, and now actually this decision by the court was provided 5 or 4 months after the first decision in the first instance that had recognized the OS deep finance. It was Judge Daniel here, and the court took 4 months or 5 months to allow this deep finance in a privileged condition to the investor. That's why this investor just quit. There was too many risks to put the money in this company at that moment, but was our first case, and now there is a precedent that established the possibility of lending money for a organization company with privilege conditional in comparison with the other creditors, despite of we don't have yet in the legislation this regulation of the deep finance. So the jurisprudence, despite of this legislation, had accepted some procedures, international procedures, had accepted deep finance, had accepted that the owner should be distinguished from the company, so we could develop and we could apply all the principles that we have in our constitution in this reorganization to save not only the companies but also the country that is in this scheme but will survive. And actually Brazil now with this bankruptcy law also had a main opportunity to investor to buy really risk-free assets and also very cheap, because we don't have a minimum price in our assets to sell in a bankruptcy court. So we have somebody, for example, land by Boi Gordo. Boi Gordo is one of our financial scheme that was from 2001 until 2004, and have almost half of a Brazilian state as land, and the investor can buy this land in bankruptcy court for less than 30% of the evaluated price of this item. So till now, instead of this, or despite of this anti-corruption or this corruption scheme, there is a land of opportunity to investor, and the institutions are a little bit stronger as on other countries to hold the investment and provide development of the country. Thank you.
Quer funcionar isso aqui? Tá.
So thank you everyone to coming here to listen to us. After those speeches, it's very hard to say a new information for you, but I have one new. Now I received the message. The José Dirceu, Henrique told, he's a new criminal complaint against about 2.4 million reais, and the corruption is today. So we work a lot and hard in Brazil for against the corruption. And the prosecutor's office in Brazil has defend a whole society, acts in bankruptcy proceeding and judicial recovery with the purpose of preserving the company, maintaining its social function and its economic activity. When a company is insolvent in act of corruption, bribery, fraud, market value suffer a concussion and the stock prices fall. The prosecution offices works to defend the public interest, supervise the application of the law, and representing the whole society. The lost company value because of corruption, bribery, and fraud cause damage to investors that must be repaired through a class action. Each in Brazil is filed by the public prosecutor representing the investors. So, ok. Eu vou pondo aqui.
Você me fala, tá bom? No primeiro.
Pode avançar.
Tá.
Here, we have a debate in Brazil about the company. Is the company is corrupt, or the human being the corruption agent? You know, we discussed about this in Brazil because, you know, a lot of people and companies depend, for example, a big company like Petrobras for the job, for the move the economy, you know. And is it okay you punish the company about the corruption? And in my opinion, in our vision, yes, it's possible to punish the company because the money to supply the corruption, you know, came to investors, and the investors put the money in company, not in the people, not in the human being. I don't know if it's clear because my English is so bad, you know. I don't speak English well, but the company used the money of the investor and for a lot of schemes for bribe, corruption, you know, and we need to look for the company and separate, you know, the goodwill in the company and the bad will, you know, and for save what is possible in this company, you know, and pay for the investor because the stock market is fall, you know, and okay. And we, in public attorney's office, we work in two fronts. One, in criminal, you know. The car wash works in criminal cases. You know, the investigation, criminal action, and as you say, no, José Dirceu is now a new criminal action. In fact, this third criminal action involved the car wash. And it's a huge job. And this is possible in Brazil, and mainly in part because we use the plea agreement, you know, because this is so important for follow the crime, follow the money, and discovery the proof for the criminal action. But this is not the only way to work. The prosecution works with reparation to investors, no? And this is my job. I don't work in this case, in the big case, I don't work in criminal way, but I work in civil way. And I start, of course, I can't say about the proof because it's in gang, seal, it's in seal, but so many things that I can say for you. And I start investigation about the conduta, help me, conduct of the company, you know, to make money with the market, and why, o que a companhia fez? What the company did for take the money with the investors, you know, and lie for investors. It's not easy to prove this. It's not easy to identify what the company do for take the money. In 2010, the Petrobras opened your stock market. Yes, the IPO, and is the biggest IPO, not IPO. Yeah, foi a maior abertura de capital do mundo.
They raised money in the market, was one of the biggest.
In 2010, you know, and they show for the market 4 or 5 projects, you know, refinarias, refiners of oil in Brazil, and oil plants. The guys help me here, and oil plants, you know. But but when you look the project, you see is the price is not a real price. It's, I don't know. Yes, it's not the real price. And the big question is, the company or the guys know the price is not real. The company know, a companhia sabia que o preço não era real e escondeu.
The company know the price wasn't real and hide it.
Yes. So
It was saying that, was the company aware that that wasn't the real price that they were showing to the investors, that it was inflated?
So, this is very difficult to know, and I work with CVM, is like a SEC here, and of course with the Lava Jato 2, and Tribunal de Contas, eu não sei se vocês têm É que eu estou trabalhando junto com o CVM e Tribunal de Contas.
Dr. Eronides is clarifying that in order to run his investigation, he's acting together with our CVM, which deals with the Security Exchange, with a tribunal for accounts of the government. We have special courts that deal with the government accounting and financial information. Well, CVM.
Tribunal de Contas e Lava Jato.
And the Lava Jato operation as well is assisting him with the evidence.
So, this is a huge investigation too, and we have, after that, one problem. How much is the damage for investors? How can I say how much the stock market fall, and because this facts? So, I don't know the answer, but I hope to, in the next year, I give the answer for you guys. Yeah. This is the name of the number of the proceeding, and I work now. So how my friends say, we have a big problem, economic problem in Brazil about the corruption. We have, Henrique fala que ligado à Petrobras,
Because of the Petrobras,
nós temos 6 milhões de desempregados.
because of
the
because of the Petrobras scheme, Dr. Eronides is pointing that we have lost 600,000 jobs, just directly related to that.
6.000 fornecedores diretos.
6,000 companies were harmed by suppliers were harmed by this scheme.
Isso sem contar o prejuízo aos investidores.
And that, besides the losses to the investors that he's also investigating.
So it's a big problem, but we have a big country too, and I hope we restart and fresh restart, without corruption, without fraud, without bribe, and so thank you so much.
I think we have a few minutes for questions. Please. Yeah.
Thank you.
Oh, that's okay.
Oh.
Well, so the question is, I represent a number of Chicago and New York hedge funds that I'm often sent to look at international projects that have gone into a distressed debt form. Now, obviously, they're there for one reason. They want to make money on the deal, but in a legitimate way. How is Brazil's law now in terms of a purchaser coming on board and looking at a company such as one of the larger ones and making a purchase, obviously at a major discount, but it can help the company resurrect its name? Thank you.
Thank you. Excellent question. Brazil is now a very good country to invest because everything is on sale and we have a lot of distressed assets to sell. And our companies need to receive new investments on that. So the hedge funds plays a fundamental role on this. We don't have, so far, a legislation regulating the deep financing, for instance. But we have already some judicial decisions on that, authorizing the deep financing and regulating in case by case how it's going to happen. I had the opportunity to do that on the OAS case. I authorized the deep financing. It was an investor from Canada, but at the end it didn't work because the Court of Appeal, they took so long to uphold my decision, and the investor quit. Simply that. But we had now a commission. The government has formed a commission of jurists in Brazil on the Ministry of Finance to study and propose a new legislation on insolvency matters, and we are discussing a lot the deep financing. So it's very likely for us to have a new legislation by the end of this year on this matter, regulating deep financing and distressed assets. It's a new market in Brazil.
We don't have the deep finance as the Judge Daniel just told us, but we have expressed clause in our bankruptcy law that would avoid any risk to the purchasers of stressed assets. So in reorganization or in a bankruptcy lawsuit, it's really safe to buy any kind of assets, but the law has just one condition, is that this buyer should purchase this asset in an auction. So it has to be a public auction by the court, so the buyer would have free risk in purchasing these assets. The most problem is that with our anti-corruption law, if this company is not in a bankruptcy lawsuit or reorganization lawsuit, this buyer had some risk because the fines in corruption, in our corruption law, the fines in administrative fine or any kind of act against the public or domestic or foreigner administration could be applied in this purchaser. So in bankruptcy, in reorganization, no, or you can buy the asset, the distressed assets. We call UPI, is like a distressed asset that was separated from the corporation to be sold, and the corporation could use this kind of money to reorganize itself. So there is no risk, but only in reorganization and bankruptcy lawsuits in an auction.
Any more questions?
Yeah. Hi, thank you for the presentation. I have two questions. Does Brazilian law require a quid pro quo for bribery charges? And if so, what's the government alleging that former President Lula did for those companies that paid for his apartment and his house?
De corrupção. Favorecimento pessoal.
There's a number of charges against him. We have to look at what stage they're looking at. some of the charges are for after 2012 when he left office, because we have a crime which is characterized as exercise improper influence. I don't know the correct translation, but from what, I don't know for which specific charge, but what the investigators are saying is that he would go and speak at different nations, Angola, Dominican Republic, get paid for his presentation there, but at the same stage, the development bank was providing loans to those countries. For the, você sabe do sítio qual foi qual é o crime, não é? Money laundering as well. He's being charged. Corruption and this. I won't be specific about the charges, but there's charges that came from the late days in office. So that construction, for example, started in late 2010, sorry, late 2010. So while he was in office and while the construction company were benefiting from the contracts with Petrobras. So, please, Stella. Quer falar? Você sabe qual o crime?
Bom, o crime é de enriquecimento ilícito.
Unjust enrichment as a crime, not as a cause, but a crime, criminal activity.
Uso indevido do cargo.
The crimes against the public entity, so the public government, including abuse of his position. Yeah, no, that's an important thing. In Brazil, the Brazilian electoral system is very transparent on one point. When you run for office, you have to list your assets. It's a public where you go on the web, you put the person's name, there's the list of assets. For example, if he owns that property and he was not listed, when he comes out of office, he also has to list what property he owns, so the authorities can check if there's any illegal enrichment by him. So that's some of those crimes that he's being investigated, and that money laundering on top of that.
And my second question is, what's the status of the 10 measures to fight corruption initiative?
Well, it was moving well. Then there was some pressure. We have to know that our Congress, half of it at least, is being investigated. And that's the Congress that needs to approve the 10 measures against corruption. It started to move fast because of pressure from the people, when the people Brazilian people went to the streets. But I think there was some, a couple of months ago, it slowed down. And now there's a big fight. The politicians are trying to approve a law that would allow them to file criminal offenses against authorities, judges, prosecutors, for abuse of authority, but very wide. You know, it's not there's a congressional dispute now to what gets approved first.
But it's a risk, you know.
That it's approved.
Yeah.
The authorities feel that the Congress will likely approve the abuse of authority first before they approve the 10 measures. And in that instance, it could really slow down everything that you have been seeing for the last 3 years, because now the authorities, not that they don't have to be careful, but when you're investigating, you have to open the investigation so you can really get to the people behind the crimes. And they're going to use this law, in our view, at least that's what I have the same impression as a lawyer, to slow down investigations. They're going to use this to say, look, you're abusing the first measure that comes out on an investigation, they're going to file for abuse. So now you have one accusing the other. Hopefully that won't pass. Hopefully there will be pressure from the people to stop that.
So there's a sort of school of thought that Petrobras is also a victim. And there's a group that says they should be able to recover funds as well. They're the victim of the government. they're the victim of their own directors. I'm wondering how the panel feels about that.
Você que a Petrobras é vítima, né?
Eu vou falar, você traduz aí.
I'll translate for him.
Yes. A Petrobras foi, como companhia, ela é vítima da má gestão, de uma gestão criminosa.
So, saying that Petrobras as an entity is the victim of its management.
É uma gestão
A
criminosa.
criminal management, in criminal management.
Mas, em relação ao investidor, ao mercado, ela não é vítima, ela é responsável pelo prejuízo.
In his view, in relation to the investors and to the market, Petrobras is not a victim. Is responsible for the damage to the investors.
Porque o investidor compra ações da Petrobras e não do presidente da Petrobras.
That the investor buys the shares of the company from the company Petrobras and not from its president.
E quando a empresa perde valor, quem perde valor é uma ação da companhia.
When the company loses value, the shares are the one that suffer the loss.
E essa perda de valor não está dentro da margem de risco usual de uma companhia.
And this loss was not within the margin of a common or regular loss that a company could suffer.
Porque você não tem como mensurar, quando compra uma ação, que pode ocorrer um ato de corrupção em larga escala, como ocorreu no caso da Petrobras.
And that you cannot, when you're buying a stock from a company, you cannot anticipate such a loss coming from this large, complex, large scheme. So, he says in his view, it's out of the margin that an investor could take as a risk. This is an extra fact.
Então, neste caso, a Petrobras ou qualquer outra companhia não é vítima.
In his view, Petrobras and any other company is not the victim. You guys have a different view on this?
I think we need to bear in mind that it's important to make a difference here. The directors, the people who is responsible for the crimes, they have to be punished. They have to be sent to the jail. But we have to preserve the company as we have to preserve the business, because it's important that we could preserve the benefits arising from a running business. So that's why in a business reorganization case, I am the judge in the first bankruptcy court, so I have many business reorganization cases. We always try to preserve the jobs, to preserve the tax revenue, to preserve the wealth, and all the benefits that comes from a running business. And we need to put aside the criminals, the criminal people, and we have to punish them. We have to get rid of them in the company, let the company go away and punish them.
Can I just say a word? Yeah, but it's not so simple in Brazil, your question. There is a group of jurists that say that the company cannot be liable for these the investors' prejudice or the investors' loss, because if we can put like the company the obligation to pay these investors, as well the company will have the value a little bit lower, and the value will reflect in the share. So in that moment, the shareholders would again have a loss. So this is questionable in Brazil. We have like a group of jurists that say that the company can be liable for this loss, and we have a huge group as well that say no, it can't. The investors should only be only file a lawsuit against the director or against the board committee, but never against the company. So, yeah, I would say it's split in Brazil, and our legislation is not so so easy in this kind of answer. Yeah, we don't have, or we didn't have until now, a case involving that, and probably we should a little bit involving about this question, but in our legislation today, we don't have a transparent, a clear answer for that.
I wanted to get your thoughts on some of the concerns that have been raised about the effects of Lava Jato and public corruption prosecutions, and specifically that these cases resulted in a political party and leader coming to power that were equally corrupt, but wouldn't have been able to win an election. And my questions for you are whether you think that corruption is equally systemic across different parties in Brazil, or whether it's concentrated in one or another, and whether you're concerned about whether there's any political agenda in which cases are selected for public corruption prosecutions.
So that has to be answered by the lawyers. The judges and prosecutor cannot issue political opinion. So if you look at the list of Odebrecht, there's no doubt that all political parties are involved. It's not, you cannot separate and say this party wasn't involved. Anyone that was a politician from 2008 forward, at least not anyone, let's be fair, there are people that are out, but all parties that were in play from 2008 forward are there. Not only on Odebrecht, but on other schemes. To your question about if it was fair, the transfer of power from a political party that could not get elected, my answer is the vice president was elected together with Dilma. They chose the vice president. So the political party that elected Dilma elected Temer as well. So he's there because he was elected. Although he wasn't on the front of the ticket, he was right behind her. And if you are against him, you shouldn't have voted for her, as an example, of course. And she was taken out of office because of a congressional decision, not of people, 300 congressmen elected by the Brazilian people. So it is a legitimate decision when the Congress, under its role and its rights and obligations, decided to take her out of office. So in the end, it is a political process, but a political process that followed the law, followed the Constitution. It's not the first time it happened in Brazil. Early 90s, Collor was taken out of office. And I particularly see it as a legitimate process.
Yeah, we say the case was so huge that reveals the way that politics was made, despite of the parties, but the way that politics was made, and also the way that business judgments were made also. So it reveals that corruption had no party and actually was involved grand part of all of our companies. So despite of ideology or parties or sectors in business, was a way to make business and a way to make politics.
Thank you very much for the presentation. This has been marvelous and very informative. But there's one topic that we spend a lot of time thinking about in criminal and civil matters in the United States that I'd like if you could address very briefly the question that this corruption situation in Brazil would raise in the United States, and that is the question of what we call facilitation liability or aiding and abetting liability. The liability of people who are helping the corrupt politicians, the corrupt business people to hide their money and to keep their money away from the Brazilian government's enforcement mechanism. So to what extent are lawyers, trustees, bankers, accountants, and other facilitators of the corruption and the hiding of the money liable under Brazilian civil or criminal statutes?
Well, there is law to make anyone that is involved in an illegal activity liable for. The question is measuring that, is understanding how much of that role, and we don't have a lot of case law that compares to what goes on in the U.S. about aiding and abetting and the amounts of damage that are usually ordered here. But there is law that would allow you to bring a claim against these parties that facilitated. Dr. Eronides would like to give an answer as an example.
O problema, dá para ouvir?
Dá.
O problema é que apurar a responsabilidade desses agentes, contadores, facilitadores, não é fácil.
He's saying that in order to measure the participation of accountants, people that facilitate, is not easy.
Porque no caso dos contadores, por exemplo, o trabalho deles não é similar a um trabalho de uma perícia forense.
He's saying that in case of accounting, their work is not similar to what they have as a judicial forensic accounting.
Então, a produção dessa prova é muito difícil. Eu tenho um caso envolvendo uma falência fraudulenta de um banco, o Banco Cruzeiro do Sul.
He has a case involving a bankruptcy of a bank.
Onde eu entrei com uma ação de responsabilidade contra a empresa de auditoria.
In that lawsuit, he listed the auditors of the bank.
Mas não é algo comum.
But it's not common. Just kidding. I think we're on time, right?
Yes, yeah.
All right, so we thank you very much. We hope we could show a little bit of what's going down in Brazil. And we'll be outside in case anybody else has any other questions. Thank you.